The U.S. Supreme Court ended its term today with a landmark decision on presidential immunity. The decision has a direct impact on former President Donald Trump's current legal troubles. CBS 2's Nidia Cavazos is live outside the Supreme Court. Nidia.
Cindy, former President Donald Trump has already declared himself as victorious in this case after the Supreme Court ruling is granting him some sort of presidential immunity from prosecution. In a 6-3 opinion, the Supreme Court ruled Monday that former presidents have absolute immunity from prosecution for official acts related to their core constitutional powers. But the court said there is no immunity for unofficial acts and gave some guidance on how lower courts can draw that line.
For those things that are just within the president's ambit, absolute immunity. For official acts in general, at least presumptive immunity. For unofficial acts, no immunity.
What's going on, everybody? Adam here. The Supreme Court issued a landmark ruling creating a 3-tier immunity framework for presidents. Absolute for core constitutional acts, presumptive for other official acts, and none for unofficial conduct, reshaping the constitutional landscape for every future presidency. The move is unprecedented and will govern all future prosecutions of former presidents. This is not hyperbole. This is not political rhetoric. This is the plain reality of what the court did on that day. Before the ruling, there was no formal framework for presidential criminal immunity. The question had simply never come before the court in this specific form. Presidents had never been prosecuted, but there was no ruling that said they were immune from prosecution. It was an open question, a constitutional unknown that had never been definitively resolved. After the ruling, there is a formal immunity doctrine with specific tiers that will define the zone of presidential criminal exposure for every future president in every future criminal case involving their presidential conduct.
The U.S. Supreme Court on Monday ruled that presidents have, quote, absolute immunity from criminal prosecution over what the justices said were, quote, official acts, in a critical case over whether Donald Trump can be charged for allegedly plotting to overturn the results of the 2020 election. The landmark ruling recognizes, for the first time ever, any form of presidential immunity from prosecution. The 6-3 decision, written by Chief Justice John Roberts, split down partisan lines and threw out a lower court's decision rejecting Trump's claims of immunity from criminal charges. It ordered the lower court to evaluate which of the alleged crimes in the indictment were, quote, official and therefore immune from prosecution, and which were, quote, unofficial and potentially criminal. The Supreme Court's slow handling of the immunity case has already helped Trump by making it unlikely that any trial on charges brought by special counsel Jack Smith could be completed before the 2024 election.
That is not a decision about Trump's cases. It is a permanent restructuring of the constitutional relationship between the presidency and criminal law. And the specific consequences of that restructuring, the incentive to route conduct through official channels, the procedural complexity of immunity fights, the delay it creates in any prosecution, will shape American governance not just for this presidency, but for every presidency that follows. The immunity ruling deserves to be understood as a genuinely nuclear constitutional move, rather than just a significant legal development in the ordinary sense. Those are meaningfully different categories, and the distinction between them matters enormously for understanding the full scope and the full permanence of what the court did. A significant legal development affects a specific case or a specific legal question. A nuclear move changes the structural rules that all subsequent cases and all subsequent legal questions operate within.
In one of its most anticipated rulings of the year, the Supreme Court declared that former President Donald Trump is immune from criminal prosecution for any so-called official act taken as president, but not unofficial ones taken as a candidate. The 6-3 ruling was split along ideological lines, and it will most likely delay Trump's federal election subversion trial until after the November election. The former president today cheered the ruling, calling it, quote, a big win for our Constitution and democracy. Marcia, start us off here. This was a ruling so many had been waiting for. It was Chief Justice John Roberts who wrote the opinion for the majority here. What's the essence of that ruling?
The Chief Justice said that very basically that certain core presidential powers are absolutely immune from prosecution. And those kind of powers would include things like the pardon power, the recognition of foreign nations, the appointment of foreign ambassadors. For all other official acts, the court said there's a presumption of immunity.
The immunity ruling was nuclear in three specific ways. First, it created something that had never existed in American law, a formal categorical framework for the criminal immunity of a former president with specific tiers that applied to specific categories of conduct. Before the ruling, there was no such framework. Presidents had never been prosecuted, but there was no ruling that said they were immune from prosecution. The question had simply never come before the court in this specific form. After the ruling, there is a formal immunity doctrine with specific tiers that will govern every future prosecution of a former president forever. Second, it sent Trump's January 6th case back to the trial court for a complex and time-consuming analysis of which specific acts in the indictment are official versus unofficial, a process that was almost perfectly designed to run out the clock. The trial court had to conduct a detailed factual act-by-act analysis of which specific conduct in the indictment falls into which immunity tier. That analysis, according to legal observers, is precisely the kind of complex legal exercise that takes months, and that once completed, generates new appellate issues that can extend the timeline further.
That's right, Cheryl. The Supreme Court's ruling has major implications on the number of legal battles that former President Trump is currently facing as he's competing to win the White House once again, especially here in Fulton County. He is facing RICO charges for allegedly attempting to interfere in Georgia's 2020 presidential election results. That's because in January, former President Trump's legal team, they filed a similar immunity motion to Superior Court Judge here in Fulton County, Judge Scott McAfee, writing in a motion that the president's absolute immunity shields him from criminal prosecution. So far, Judge McAfee has not ruled on that motion. Former Gwinnett County DA Danny Porter says he believes the judge is waiting to see how the justices of the Supreme Court decide the federal immunity case before he issues his ruling. Take a listen.
The immunity ruling did not end Trump's criminal cases outright. It installed a new and unprecedented layer of legal process between the evidence and any potential trial. And that new layer, combined with the appellate review it generates, was precisely enough to prevent any verdict before he returned to office and the sitting president prosecution bar took effect. Third, it established a precedent that future presidents, including Trump in his second term, can use to claim official act immunity for a wider and wider range of conduct as the doctrine is interpreted and extended in subsequent cases. That last consequence is the most long-term and the most structurally significant. The immunity ruling is not just a shield for Trump, it is a blueprint for every future president who wants to expand the zone of official conduct and contract the zone of criminal exposure. Every future president who wants to engage in legally questionable conduct has a structural incentive to frame that conduct as official rather than private, to use the mechanisms and resources of the official presidential role to accomplish goals that, if pursued through private channels, would expose them to criminal liability. The ruling does not make presidents above the law for unofficial acts, but it creates a structural incentive embedded in the constitutional framework of the presidency by a formal Supreme Court ruling to route as much conduct as possible through official channels and official mechanisms that receive immunity protection. The second nuclear move from the court operates as the essential other side of the same strategic and constitutional outcome. The Trump versus Anderson ballot disqualification case, decided unanimously in March of 2024, eliminated a completely different category of accountability mechanism from the menu of available options for holding Trump responsible for his conduct. Together with the immunity ruling, Anderson forms a two-part structural package that fundamentally reshaped the accountability landscape. In a unanimous decision, the court reversed Colorado's attempt to remove Trump from the presidential ballot under the 14th Amendment's insurrection clause, holding that states cannot unilaterally bar presidential candidates through the insurrection provision without congressional action. That ruling eliminated one of the most significant legal strategies available to Trump's opponents for preventing his return to the White House. The argument that his conduct on January 6th constituted participation in an insurrection that constitutionally disqualified him from holding federal office again. The court did not say he had not participated in an insurrection. It said that even if he had, states acting alone through their own electoral processes do not have the authority to enforce the 14th Amendment's disqualification. Together, those two rulings, immunity from prosecution for official acts and insulation from state-level ballot disqualification, constitute the structural nuclear package. The combination incinerated the two main legal pathways that existed before those decisions for holding Trump accountable through processes other than elections. The court did not rule on the merits of the accountability question. It ruled on who decides the accountability question. And its answer effectively was that, in a democracy, the voters decide, not the courts and not the states. That is a defensible constitutional philosophy, but it is also a philosophy that produced specific, immediate, and identifiable consequences for the accountability of a specific person for specific conduct. Before the rulings, a plausible argument existed that states could remove Trump from their presidential ballots under the 14th Amendment's insurrection clause if they concluded his conduct on January 6th met the constitutional definition of engaging in insurrection. That argument was eliminated by Anderson. Before the rulings, a plausible argument existed that the January 6th indictment could proceed to trial and potentially verdict on a timeline that would produce a judicial finding about Trump's criminal conduct before the election. That timeline was eliminated by the immunity ruling's requirement of act-by-act official versus unofficial analysis. Together, those two decisions removed the legal mechanism and the judicial mechanism for pre-election accountability. What remained was the electoral mechanism, the question of whether voters would hold Trump accountable at the ballot box. The court did not rule on the merits of the accountability question. It ruled on who decides the accountability question. And its answer effectively was that in a democracy, the voters decide, not the courts and not the states. That is a defensible constitutional philosophy. But it is also a philosophy that produced specific, immediate, and identifiable consequences for the accountability of a specific person for a specific conduct. In the legitimacy debate that legal scholars have been having since the rulings came down, the debate is about whether those consequences were produced by neutral legal reasoning or by something less neutral. And that debate matters because it shapes how the public perceives the court and its rulings. The specific structure of the immunity doctrine, tier by tier, is what determines the practical scope of Trump's criminal exposure going forward, and what determines whether investigations can ultimately produce the outcomes prosecutors were seeking before the ruling came down. The absolute immunity tier covers actions within what the court described as the president's conclusive and preclusive constitutional authority. The core functions of the presidency that only the executive branch can perform, including commanding the military, conducting foreign policy, pardoning offenses against the United States, and managing the operations of the executive branch. For conduct in those categories, the court ruled a former president is absolutely immune from criminal prosecution. The government cannot even present evidence about such conduct to a jury. The presumptive immunity tier covers official acts more broadly, acts that are taken in the course of carrying out the functions of the presidential office, even if they fall short of the absolute core. For those acts, there is a presumption of immunity that can only be overcome if the government can show that prosecution would not unduly intrude upon the functioning of the executive branch. And the no immunity tier covers unofficial acts, conduct that is private, personal, or campaign-related, rather than governmental. The court was explicit that the immunity doctrine does not apply to unofficial acts, and that a former president can be prosecuted for such conduct under the same standards as any other citizen. The practical consequences of that three-tier structure for Trump's January 6th case are profound. It required the trial court to conduct a detailed factual act-by-act analysis of which specific conduct in the indictment falls into which immunity tier. That analysis, according to legal observers who watched the proceedings, is precisely the kind of complex legal exercise that takes months, and that once completed generates new appellate issues that can extend the timeline further. The immunity ruling did not end Trump's criminal cases outright. It installed a new and unprecedented layer of legal process between the evidence and any potential trial. The act-by-act official versus unofficial analysis, and that new layer, combined with the appellate review it generates, was precisely enough to prevent any verdict before he returned to office, and the sitting president prosecution bar took effect. The timing of the ruling in the final months of the election year, after years of delay, and the procedural consequence of the ruling, an additional layer of immunity litigation that would take months to resolve, produced a specific and identifiable outcome. The cases that might have produced a verdict before the election did not. And the sitting president now benefits from both the immunity doctrine and the prosecution bar simultaneously, creating the most comprehensive personal legal protection any American president has ever held. The structural consequences of the immunity ruling that go beyond Trump's specific cases will shape how the institution of the presidency itself functions for decades. Legal scholars have identified a set of structural consequences that they describe as genuinely alarming. The first is the perverse incentive the ruling creates for future presidents to maximize the range of conduct they claim as official. If absolute immunity applies to core constitutional functions and presumptive immunity applies to official acts more broadly, then every future president who wants to engage in legally questionable conduct has a structural incentive to frame that conduct as official rather than private, to use the mechanisms and resources of the official presidential role. The communications apparatus, the national security infrastructure, the powers of appointment and removal, to accomplish goals that, if pursued through private campaign channels, would expose them to criminal liability. The ruling does not make presidents above the law for unofficial acts, but it creates a structural incentive embedded in the constitutional framework of the presidency by a formal Supreme Court ruling to route as much conduct as possible through official channels and official mechanisms that receive immunity protection. The second structural consequence is the complexity it adds to any future prosecution of a former president. Before the ruling, the question was whether there was sufficient evidence of criminal conduct. After the ruling, the threshold question is whether the specific conduct at issue is official or unofficial, a question that requires extensive factual and legal analysis and that generates multiple levels of appellate review. Every future prosecution of a former president will begin with an immunity fight that could last years before any trial on the merits can proceed. The ruling is not just a doctrine. It is a procedural weapon that protects former presidents from accountability through delay, regardless of the strength of the underlying evidence. The combination of that procedural weapon with the electoral channeling of accountability decisions produces a presidency that is systematically better insulated from criminal accountability than the original constitutional design contemplated. The court's current posture on Trump-related cases more broadly reveals an institutional asymmetry that has developed in how the court handles cases involving the current administration. The Lawfare Litigation Tracker documents more than 14 Supreme Court stays or orders vacating lower court rulings in cases involving Trump administration policies, compared to only one full affirmation of a lower court ruling against the administration. That asymmetry is significant. A court that steps in more often to block lower court rulings against the president than to affirm them is a court that is functionally providing more institutional protection to that president than a neutral arbitration of legal questions would produce. That asymmetry does not prove partisan motivation. Courts step in for many reasons, and not every stay reflects a substantive judgment about the merits of the underlying case. But the pattern documented across dozens of cases and multiple policy domains is one that produces a specific institutional effect, a presidency that faces less immediate legal resistance from the highest court in the land than the historical baseline would suggest. The active docket still contains more than 150 entries for cases involving Trump in some role, from the birthright citizenship challenge, to immigration enforcement, to the tariff authorities that the court has already struck down, to multiple questions about the scope of executive power in specific policy domains. Each new ruling in those cases is an event that reshapes the political and legal landscape in ways that produce shock and eruption, because each ruling, whether it expands or contracts the zone of presidential authority, is a ruling by the most powerful legal institution in the country on the specific question of what this specific president can and cannot do. And in a presidency defined by constant testing of constitutional limits, every court answer to a constitutional question is itself a political event of the first order. Multiple legal scholars have concluded that the court is experiencing a legitimacy crisis, that the immunity ruling both reflects and deepens. Scholars at the University of Oregon Law School analyzed Trump versus United States under the title Signs of a Court in Crisis, and have argued that the immunity ruling is not just legally significant, but reveals something about the court's own institutional condition. A court that is struggling to maintain its legitimacy in a highly polarized political environment faces a specific temptation to issue rulings that manage political outcomes rather than pure legal questions in ways that reduce the institutional. Confrontations that would otherwise test whether presidential compliance with court orders is reliable. The immunity ruling, by dramatically expanding the zone of protection available to a former president facing unprecedented criminal prosecution, managed the most significant institutional confrontation the court faced between a Republican-appointed majority and a Republican president's criminal liability in a way that reduced the confrontation. Whether that management was motivated by political calculation or by sincere constitutional reasoning is a question legal scholars will debate for decades. What is not debatable is that the ruling changed the constitutional landscape in a way that produced specific and immediate benefits for the president, whose party appointed a majority of the court. And that confluence, regardless of its cause, is what produces the perception of a court in crisis. The Trump versus Anderson ballot disqualification ruling, together with the immunity ruling, constitutes a two-part structural package that eliminated the two primary non-electoral pathways for holding Trump accountable for conduct connected to his efforts to remain in power after the 2020 election. And the combination represents a choice by the court to channel all accountability questions through electoral politics rather than legal processes. Before March of 2024, a plausible argument existed that states could remove Trump from their presidential ballots under the 14th Amendment's insurrection clause if they concluded his conduct on January 6th met the constitutional definition of engaging in insurrection. That argument was eliminated by Anderson. Before July of 2024, a plausible argument existed that the January 6th indictment could proceed to trial and potentially verdict on a timeline that would produce a judicial finding about Trump's criminal conduct before the 2024 election. That timeline was eliminated by the immunity ruling's requirement of act-by-act official versus unofficial analysis. Together, those two decisions removed the legal mechanism and the judicial mechanism for pre-election accountability. What remained was the electoral mechanism, the question of whether voters would hold Trump accountable at the ballot box. The court did not rule on the merits of the accountability question. It ruled on who decides the accountability question. And its answer effectively was that in a democracy, the voters decide, not the courts and not the states. That is a defensible constitutional philosophy. But it is also a philosophy that produced specific, immediate, and identifiable consequences for the accountability of a specific person for a specific conduct. In the legitimacy debate that the University of Oregon analysis described, the debate is about whether those consequences were produced by neutral legal reasoning or by something less neutral. The court's current docket on Trump-related cases reveals what the ongoing constitutional confrontation between this presidency and the legal system looks like. The court is deciding approximately 23 cases before the end of the term, a term that legal observers describe as one of the most consequential in decades, specifically because of the number and significance of the cases involving executive power and presidential authority that have been accepted for argument. Multiple of those cases directly involve Trump administration claims of executive power that lower courts have either upheld or struck down, and the Supreme Court's decisions in those cases define the operational boundaries of this presidency in ways that the immunity and Anderson rulings set the constitutional framework for, but did not fully resolve. The tariff case already produced a ruling that found Trump broke the law with two of his own appointees joining the majority. The birthright citizenship case produced oral arguments where multiple justices expressed sharp skepticism about the legal theory supporting his executive order. The broader docket of immigration, executive power, and federal enforcement cases contains multiple additional opportunities for rulings that either confirm or limit the extent to which the immunity doctrine and the court's general posture of stepping in on Trump's behalf translates into support for his specific second-term policy agenda. Watch for any case involving the scope of official act immunity where the court is asked to define the line between official and unofficial conduct in a more specific factual context, because that definition will directly determine the remaining scope of Trump's criminal exposure in the cases when the sitting president bar is lifted. Watch for the birthright citizenship ruling specifically, because a ruling that upholds Trump's executive order would establish that the president can reinterpret the 14th Amendment by executive action, which has implications that go far beyond immigration policy to every constitutional provision Trump might want to reinterpret unilaterally. Watch for any case in which the court reverses its prior pattern and affirms a lower court ruling against the administration, because a ruling of that kind from a court that has been stepping in on Trump's behalf would signal that the presumptive deference has reached its constitutional and institutional limits. The nuclear moves have already been made, the consequences are already in motion, and the remaining rulings in this term will tell you whether the court that pulled those moves is willing to follow them to their logical constitutional conclusions. The immunity ruling is the most consequential single Supreme Court decision affecting the presidency in the modern era, because it created an entirely new framework for presidential criminal immunity that had no precedent in American constitutional law, and that will govern every future prosecution of a former president, regardless of what they did or who brings the case. Every previous significant Supreme Court decision in the area of presidential power worked within a framework that assumed presidents could eventually face criminal accountability for conduct that violated criminal law. The Trump immunity ruling is different in kind because it created a categorical framework that applies independent of the specific facts of any particular case. It established categories of presidential conduct, absolute immunity for core constitutional functions, presumptive immunity for official acts, no immunity for unofficial acts. That will define the zone of presidential criminal exposure for every future president in every future criminal case involving their presidential conduct. That is not a decision about Trump's cases. It is a permanent restructuring of the constitutional relationship between the presidency and criminal law. And the specific consequences of that restructuring will shape American governance, not just for this presidency, but for every presidency that follows.